In 1997, Patrick Bolitho, a 2-year-old child, was admitted into the hospital for respiratory difficulties and was placed under the care of Dr. Horn. Dr. Horn did not see the patient when the nurse had called her. The child recovered but collapsed subsequently, and on second occasion, the doctor delegated the care to another doctor, her junior, Dr. Roger. This doctor also did not see Patrick. This led to further complications in the patient and then severe brain damage, from which Patrick eventually died. This was really tragic. In the suit against the hospital for negligence, it was argued that Patrick would have lived if he had been intubated. Hypothetically, if you were the judge, what would be your verdict? Answer this question in the platform provided. Thank you for participating in the question that was given to you earlier on. Now, let's check out the verdict of this case. The real verdict, I mean. It was admitted that Dr. Horn had breached her duty of care in not coming to see Patrick. But Dr. Horn argued that even if she had come to see Patrick, she would not have intubated him. Therefore, Dr. Horn's argument was that her breach of duty did not cause Patrick's death. As to whether any competent doctor should have intubated if he had attended Patrick, the judge had evidence from 8 medical experts. 5 of them were called on behalf of Patrick and were of the view that, at least after the second episode, any competent doctor would have intubated. That's the only way to save the child, but with risk. On the other side, the hospital called 3 experts, all of whom said that, on the symptoms presented by Patrick as recounted by the nurses, intubation would not have been appropriate. The child is too young. Even the doctor was present. He will not be intubated. Intubation is not a routine, risk-free process. Patrick's symptoms did not suggest a progressive respiratory collapse, and there was only a small risk of total respiratory failure, which did not justify the invasive procedure of intubation. This view is logical, according to the judge. It involved anesthetizing and ventilating the child. A young child does not tolerate a tube easily, at any rate for a day or two, and the child tends to remove it unless sedated. In those circumstances, it cannot be suggested that it was illogical for Dr. Dinwiddie, a most distinguished expert, to favor running what, in his view, was a small risk of total respiratory collapse, rather than to submit Patrick to the invasive procedure of intubation. This means that the judge is entitled to choose between 2 bodies of expert opinion and to reject an opinion which is logically indefensible. And this gives rise to the Bolitho Test. The court reserves the right to strike down a medical practice deemed unreasonable. This has been interpreted as being a situation where the court sets the law, not the medical profession. On the facts of the case, it was decided that not intubating the child in the particular circumstances at hand was not a negligent way to take, even though the expert opinion on the matter was divided. In 1999, Nadine Montgomery gave birth by vaginal delivery to Sam. The birth was complicated by shoulder dystocia. Simply means the baby's shoulder gets caught above the mother's pubic bone, so it's very hard for her to come out. Medical staff performed the appropriate maneuvers to get Sam out, but during the 12-minute delay, he was deprived of oxygen and subsequently diagnosed with cerebral palsy. Mrs. Montgomery is diabetic and of small size, and the shoulder of dystocia risk was agreed to be 9 to 10%. Despite expressing concern to a consultant about whether she would be able to deliver her baby vaginally, the doctor failed to warn Mrs. Montgomery of the risk of serious injury from shoulder dystocia, or the possibility of an elective cesarean section to prevent the surgery. Mrs. Montgomery filed a lawsuit alleging that she should have been advised of the 9 to 10% risk of shoulder dystocia associated with vaginal delivery, notwithstanding the risk of a grave outcome was small. Option of cesarean section ought to have been offered to Mrs. Montgomery, and that this would have prevented the child's injury. The hospital argued that only the risk of a grave adverse outcome triggered the duty to warn of such risks, and that because the risk of such an outcome was so low, and that an expression of concern was not the same as a direct question requiring a direct answer, no warning was required. Now, based on the facts of this case, and hypothetical question for you is this: if you were the judge, what would be your verdict? Based on these facts of the case, answer this question in the platform provided. Alright, by now, all of you should have answered the hypothetical question if you were the presiding judge for Bolitho, Bolitho, and now the Montgomery case. I'm aware that some of you were very upset and you probably felt that it's unfair because both Bolitho and Bolitho did not win the lawsuit. For Bolitho, he suffered an injury, and for Bolitho, he's no longer here. And that's really a very tragic case. And I can totally understand your feelings because I do feel the same way. But if you understand the judge's decision to why the verdict was made, then perhaps you could have a better understanding of how law works. And for this case, Montgomery, let's check it out if the court ruled in favor of the patient or the hospital. So, the Supreme Court held that the question should have been about Mrs. Montgomery's likely reaction if told of the risk of shoulder dystocia. The clear decision was that she would have chosen to give birth by cesarean section. The Bolitho test was deemed unsuitable for cases regarding the discussion of risk with patients, as the extent to which a doctor may be inclined to discuss risk with patients is not determined by medical learning or experience. The court ruled that Mrs. Montgomery should have been informed of the risk of shoulder dystocia and given the option of a cesarean section. Clearly, the court ruled in favor of the patient, Mrs. Montgomery. Mrs. Montgomery was awarded $5.25 million in damages, and that gave rise to the Montgomery test. So now you have learned about the 3 types of tests that is used to determine the standard of care in Singapore. So first is Bolitho test. I'm aware that some of you are quite upset with the outcome of the case because some of you felt that it is unfair. And well, there is critique about the Bolitho test because it favored the medical men, which is the doctors. And for the Bolitho test, the judge followed what the medical experts say. And for Bolitho test, the judge can follow what the medical views is, but if the judge finds that what the medical experts say is not logical, the judge can strike down the will and form his own will. However, this is rare because the judge is not a trained doctor, so a judge usually relies the medical expert heavily when it comes to making a decision. And now we have Montgomery test, and this test gives rise to the importance of a patient in terms of disclosure of risk. And as you can see, that from Bolitho Test, we have Bolitho Test and Montgomery Test, we are now more patient-centric, because for Bolitho Test, in my view, is very much doctor-centric. So this is the evolution of the law in Singapore.